Have you been paying Mr. Knox child support?
No.
And so Mr. Knox has, for this period of time, been solely financially supporting the child while in his household?
Yes, while in his household.
How much money did you give Miss
I don't
Stevenson?
know. I
How
don't.
much money? How much money did you give Miss Stevenson for the support of Bella? Not what you bought, not what you got for your daughter, not what services you paid for. How much cash did you give to Miss Stevenson?
It's a state's understanding that the ad litem and state and father were all wanting to finalize the further temporary order as is. However, it's a state's understanding that Ms. Brown is wanting to be named primary conservator of the child. The parties initially had a temporary order where that was the case. The further temporary order switched conservatorship, and the state will defer to Ms. Lambert as to whether there are any recommendations or concerns about either. The state did have a remaining issue for finalization, which was retroactive or back child support prior to the orders from August of 2022. However, it's the state's understanding parents will testify to the child having been in both households and wanting to go forward with current support only. It's just the state is required to ask, Your Honor.
All right, then I'll ask Ms. Lambert, so is this a fully blown contested custody matter? Or is this, what are we looking at as far as hearing time today? Because again, I don't do custody matters on general dockets. It's just not going to be time feasible. So what do you got, Ms. Lambert?
Yes, Your Honor. I believe that based upon just a few questions, the court could be prepared to make a ruling fairly quickly today. I don't believe it's something that needs to be extremely drawn out. However, the mother obviously does have the right to make her request. The court has already placed the child with the father. Even in the initial temporary order where mom was made primary, it was later established the child had been with the father that entire time, and primarily since 2020. And so again, it's the mother's request, but I don't believe this is something that's really highly contested. I think the facts and testimony will show fairly quickly that the child ought to remain with his father. Can you please state your first and last name for the record?
D'Angela Brown.
And who are you in relation to the child in this case?
His mother.
And do you have any other children with Mr. Knox?
No.
And does your son have any siblings that reside with you?
Yes.
How many siblings does he have?
2.
And what are the ages of those 2 siblings?
17 and 14.
And so how is it that your son came to live with Mr. Knox?
First, it was October 2020. I was going through some postpartum and wasn't working at the moment and just needed some more help. At the time, he wasn't going with he wasn't getting them every other weekend or weekend. So I had emailed his sister that I needed help, and she was about to come get him, and that's when Mr. Knox came to get him, and he stayed with him for a few months until I got him back, I think around January. And then the last time it happened, because I was in the process of moving from Killeen to Austin and didn't have a job. And this was back in August of last year, I guess, when we had court, and I told you guys it would be best for him to stay with his dad at the moment because his dad could afford childcare, and I couldn't because I was in between jobs.
Okay. And so between October 2020 and January of 2022, your son was going back and forth between your 2 homes, is that right?
Yes, that's correct.
Okay. And so what would those periods of times look like? Are we talking every other week, or were these months at a time?
It was different months. So I had when he went with his dad in October 2020, he came back with me for, I believe, for January, February, those couple of months. Then he went back with his dad. Then I got him in May or June of 2021, and I had him all that time. That's when Mr. Knox got his case in August of 2021. And then he went back with his dad at the end of December of 2021.
And so he's been primarily living with dad since December of 2021 until current, is that right?
Yeah, in between the summers and stuff. Yeah, he's had him mainly during the school year when he was able to afford daycare.
And so from that period of time of January, let's just start January 2022 until current, have you been paying Mr. Knox child support?
No.
And so Mr. Knox has, for this period of time, been solely financially supporting the child while in his household?
Yes, while in his household. I have things in my household.
And you have a standard possession schedule currently?
What is that?
Where you
every other weekend?
Yes, first, third, and fifth?
Correct.
Okay. And so why is it that you believe it would be in your son's best interest to be removed from his father's home where he's been since January of 2022?
Well, back in August of 2022, when we suggested we were both on the same page about him having him for a while, but then things changed in October of 2022 when a case was filed, when he brought charges on me, Mr. Knox. So ever since then, the past year, it's been really hard for me to see my son. As you know, we went through the whole month of July where I didn't even see my son at all. It's been hard to get in contact with him. He didn't want to follow through with a court order about contacting me through the app Close. Our son has seizure issues, and sometimes I get made aware of things afterwards. I have to contact his mother. That's how we were generally going through contacting each other, was through his mother, and it's kind of hard to understand her because of we're text messaging. So it's just been really hard for me to even get my son. Before the case and all this had happened, we were on the same page. I was able to get my son whenever, get him through the week. There was no custody issues. It just happened when this case came about. And now it's just been completely difficult to get my son or see him.
And so hold on for a second, make sure the judge is aware. So when you keep saying the case, you're referring to when assault charges were pressed against you by Mr. Knox for assault in August of 2022?
Correct.
Okay. And subsequently, those charges were dismissed, correct?
Yes, correct.
And so during that period of time, after those charges were pressed, the two of you were ordered not to have contact?
Correct. Or we were supposed to meet at the Springdale police station, which we never did.
Okay. And so when you say that Mr. Knox was not being responsive to you through text and was asking you to go through his mother, do you suspect that was because he was not supposed to have any direct contact with you during that time?
I'm not sure. I sent over. I'm just not sure. I'm not sure what happened on his end. On my end, I know I was not made aware to not contact him, especially if it was about our child.
But you do agree that prior to this assault charge that the two of you were texting or communicating fine?
Correct.
Okay. So subsequently, after the charges were filed, communication died off. Now these charges have been dismissed. And so now you, although you would voluntarily relinquish the child to the father, believe that the child should reside with you.
And I'm only saying that because I've had limited contact with my son. If we were to be on the same page, if there's a way we can work out a custody agreement.
Ma'am, here's the deal. You're going past the question.
Okay.
I know I'll let you go there for a while in the narrative. But from now, you need to just listen to the question, answer the question, and at the end, ma'am, I'll allow you to tell the court any other additional reasons. But for right now, you need to just deal specifically with the question. Thank you.
So just to clarify, your request is now that your child be removed from his father's home and that you be made primary. Is that correct?
Correct.
And you're stating that one of your primary reasons for that is because you feel like since he's been with dad, you've had limited access.
Correct.
Do you have any specific events where you showed up to the visitation spot or reached out to dad and he denied visitation?
I'd have to go through our messages. I'm sure it happened earlier this year. I don't know. I would have to go through my messages and see through the app Close.
Okay. Because you've mentioned that not having as much access as you would like is one of your motivating reasons, which is understandable. Would you be opposed, instead of being made primary, having extended visitation where you would pick your son up Thursday evenings after school and then take him to school on Monday?
I would not be opposed to that.
Okay.
Yeah, man, where you live right now?
I live in Del Valley right now.
Okay.
Del Valley, Texas.
Okay, I know where it is. Del Valley was we played football against them in Belton in the back in the 70s. So yeah, I know exactly where Del Valley is. Hated going paying that little school. Those dudes were tough. So yeah, never mind. Go ahead.
Okay. And Ms. Brown, Mr. Knox lives in Austin. Is that correct?
I'm not sure. I know my child goes to school in Round Rock, and Mr. Knox doesn't live in Round Rock. So.
Okay. Approximately how far do you live from your son's school?
Let me double check. 24 miles.
Okay. Thank you, ma'am. I don't have any further questions at this time, Your Honor.
All right, Ms. Bongad, you're a witness.
Thank you, Your Honor. Ms. Brown, before the child support process began, you and the father were not exchanging any type of monetary support, were you?
The only support, well, if he was supporting cash, it was through Cash App. Anything else he would buy on his own, like he would buy it.
And so, ma'am, was I correct in telling the court earlier that you were wanting to go forward, not look back at any time frames where retroactive support should have been paid?
Correct.
And ma'am, as far as the amounts that you received through Cash App, what total would you think there was given to you by Mr. Knox?
I have no idea.
And so, ma'am, would you say that money was given on a regular basis or after some type of request from one of you?
After a request.
And did money exchanges range from as low as $50 to as high as $400, again, depending on what the specific need was for your son?
Yeah, I'd say range from anywhere between like 15 to maybe 150.
And while these weren't regular transactions, would you say that anything your son needed, Mr. Knox was able to provide, and you have no request for anything back at this time?
Yes, that's correct.
Okay. You understand, ma'am, that with the further temporary order, you were the person ordered to pay support to Mr. Knox, correct? And you understand, ma'am, that that was all based on the minimum wage presumption at that time?
Yes.
Has your income changed, ma'am? As in today, are you making something different?
Yes, right now I'm at a temp job, so it's more than minimum wage.
What is your hourly pay?
$18.
And how many hours per week do you work?
About 40.
And does this job offer any benefits such as health or dental insurance?
Yes.
And are you eligible for that at this time?
Yes.
Do you know what the cost would be to enroll your son in this employer's in health and dental?
I'm not sure. I believe the enrollment is open right now, so I would have to double check and get back with you.
And you mentioned you have two other minor children in your household, ma'am.
Correct.
Are either of them covered by this employer's insurance?
Uh,
Let's see. Given your son's age, do you believe he would benefit from having electronic communication ordered in addition to the in-person visitation you and Mr. Knox get?
yes, I believe so.
Thank you, ma'am. Your Honor, I pass this witness.
All right, ma'am. I'm going to be back in just a moment. I'm going to let's hear from Dad, and then I got a couple of specific questions I want to ask you, ma'am. All right. Thank you. I may proceed. Is there any? I'm sorry, Ms. Lambert. Anything on redirect?
No, Your Honor.
All right, then call your next witness, please. Thank you.
Mr. Knox, will you please state your first and last name for the record, sir?
James Knox.
And who are you in relation to the child in this case?
I'm his father.
Okay. And is it correct that your son has been residing with you primarily since January of 2022?
Yes, ma'am.
And prior to that, did you and mom switch off possession of the child for months at a time?
Yeah, like some months she would have him, and then I had him like for a little while, and then like around the holidays, I say maybe like around December and January, and then she get him like spring break, and then summer for summer. She had got him 2 months to one summer, and then this past summer she got him for 1 month.
Okay. And so the time that you guys were flipping back and forth before January 2022, your son was approximately 2 years old?
Yes. Well, before he was about 14 months whenever I started, when he actually moved in with me. And then, so like I say, a couple of months went by, and then he would stay with her, and she would keep him for a month, and then he would come back with me.
Okay. So just to keep it concise, so he wasn't enrolled in any school programs or anything like that at the time when he was kind of bouncing back and forth between the two of you?
He was in daycare and maybe
but not like a learning program, not any curriculum or anything?
No curriculum, no learning program, just basic daycare and stuff like that.
Now, currently, is he enrolled in a pre-K program?
Yes, he is.
Okay. And where is he currently enrolled?
Seventh-day Adventist Academy.
Okay.
In Round Rock.
And did you enroll him there?
Yes, ma'am.
Okay. What city do you currently reside in?
I stay in Austin.
Why is he enrolled in a school in Round Rock?
Well, he's enrolled in the school in Round Rock because I work. My little part-time job is in Round Rock, and he's been going to the academy ever since he was in daycare. And also, I didn't have no documents to, even if I wanted to register him into a school or academy down the street, which I needed certain documents like birth certificate and stuff like that, which I didn't receive whenever I went to go try to pay money and receive them.
Okay.
And so.
And is there a tuition or a cost associated with him attending the school?
Yes, I paid $485 a month.
For his tuition?
Yes, ma'am.
Okay. And you've not received any child support or financial support directly or through the state from Miss Brown since your child's been residing with you?
No, ma'am.
Okay. Do you agree that your son came to reside with you as a result of mom voluntarily relinquishing due to her having a hard time financially?
I could say that was, part of it.
Okay. Do you believe that it's in your son's best interest to remain living with you?
Yes, ma'am.
Do you believe that you're providing him a stable, loving environment?
Yes, ma'am.
Do you in any way believe that Miss Brown is unfit?
No, I don't think that she's unfit.
Okay. Miss Brown introduced testimony regarding the incident that occurred in August of 2022. That is when you filed assault charges against Miss Brown. Is that correct?
This actually was in October of 2022.
Okay. And you're aware that those charges have been dismissed?
Well, I was aware today.
Okay. And the charges that were filed against you by Miss Brown, those have also been dismissed. Is that correct?
Yes, ma'am.
Okay. And so to the best of your knowledge, neither of you have any pending charges for family violence or assault against you?
No, ma'am. No pending charge.
Ms. Brown testified that after this incident occurred around August or October of last year, your communication with her declined. Was that the result of the incident that occurred?
Yes, because, I was having, problems with communicating with her, and my lawyer just thought it was in my best interest not to communicate unless it was through a parental app or something like that, or just to have a parent to, do the exchange that way, just to keep, so she can't say anything or say that I did anything or anything like that.
And when you say your lawyer, you're referring to your criminal lawyer?
Yes, ma'am.
And our further temporary order also ordered that the two of you would communicate through app close and do the exchange with a third party in a public place. Is that right?
Yes, ma'am.
Okay. Would you be opposed if Miss Brown was given extended visitation where you still remain primary, but she has your son for an extended period of time? So for the first, third, and fifth weekends, she may pick him up from school or at 6 o'clock at the meeting place, and then she's responsible for taking him back to school on the following Monday.
Yeah, that's fine. Like I've said, I've never had no problem with her picking him up at school or dropping him off or getting him any weekend that she wants to pick him up on.
Do you think that it's possible now that the assault charges have been dismissed between the two of you for you guys to get back on the same page with the co-parenting relationship and increase your communication?
I mean, we can work on it. Like I say, it's a communication thing too. So, I'm willing to try anything, as far as, my son concerned. So.
Okay. During the initial temporary order where you were ordered to pay mom support, did you pay any support under that order?
No, because I couldn't afford to pay it because I was paying daycare.
Hey, sir, here's the deal. Just like I told mom.
Okay, no.
Answer the question. It's a yes or no. All right, thank you.
No.
And is that because your son was physically living with you at that point in time?
Yes.
Okay. No further questions, Your Honor.
All right, Ms. Bongad, you're a witness.
Thank you, Your Honor. Mr. Knox, you have worked and paid your taxes for the past 2 years. Is that correct, sir?
Yes.
And sir, are you aware of funds based on you paying taxes being applied to your child support case?
Yes, they took some money amount for child support.
And so, sir, if you had gotten a chance to look at the email sent with the pay records, a balance of 32 cents wouldn't surprise you?
Not that I know of, because I got a paper that says 0, so I don't know.
Okay. And then as far as Ms. Brown being ordered to pay you support, have you received any of it?
No.
And as far as the time prior to the child support order starting, sir, you and she are in agreement that you did give her Cash App and other actual funds regarding or for the support of your son or her household?
Yes, ma'am.
What amount, sir, did you give on total or as much as you recall?
I really don't know the total amount, but from times like maybe weekly, $50 to $100 a weekly if needed. And like I said, or I would just buy some stuff that he needed that week or whatever, or for 2 weeks or however. We just communicated if she needed something, like she might say, well, I need groceries for it, and I'd send her 50 to 100. And then if she needed something else, I'd send it next week. Or so I really don't have a recollection of how much. I never really kept track.
And sir, with your current job, how long have you had it?
I just started back this job in October of last year.
Okay. And prior to that, sir, was the income we used to set your support obligation. How long had you been earning that amount?
About, I guess about 2 years.
And sir, how old is your son at this point?
4.
Do you have any other minor children?
No, ma'am.
How does your son have health coverage at this time?
He has health coverage through Medicaid, but it expires today.
And sir, the current one that's expiring today, is that something you're responsible for or that Miss Brown was?
I guess she's responsible because they sent her the letter. They never sent me a letter, so.
And so, sir, based on your child's coverage expiring today, do you know whether you'd be able to add him to yours if given the opportunity?
I tried to add him to mine when we first started, and they said he wasn't old enough to get on mine. So, but I can try to call again now that it's expiring today and maybe see what they can do.
Okay, I'm sorry, sir. They said the child wasn't old enough to be on family plan for health insurance?
Well, I don't know. I'm on SSDI, so I don't know why.
Oh, okay.
So whenever I called and tried to put him on it, they said that he wasn't old enough to be on there. So it kind of threw me in a loop because it's my first time trying to even.
All right. So with your SSDI, do you get Medicaid?
Yes, sir.
Okay. So, all right. Okay. Well, if I leave him with you, then I'll have the ad litem double check that and make sure that gets taken care of one way or the other. All right. Thank you. You may proceed. I'm sorry, Ms. Mongat.
Thank you, Your Honor. And Mr. Knox, does your current employment provide any benefits such as health or dental insurance?
No, ma'am.
Thank you, sir. Your Honor, I pass the witness.
All right, then. Anything on redirect, Ms. Mongat? Ms. Lambert? Thank you.
No, sir. No.
All right, then. All right. Any other witnesses either you wish to call at this time, Ms. Lambert?
No, Your Honor.
All right, Ms. Mongat, any other witnesses?
No others, Your Honor.
All right, then. All right, this time, Ms. Brown, is there anything in addition to what was testified to here today that you want to tell this court that is, again, it's got to be relevant to what we're doing here today, ma'am? Why you think the court should name you as a conservative with the right to side domicile? If there's any other data, ma'am, I'll let you make a closing statement in a moment. But is there any direct testimony you want to give at this time?
No, not at this time.
All right, Mrs. Knox, any direct testimony you want to add, sir? I'm sorry, sir. Did you say something? Okay. Is there anything else you want to add, sir?
No, sir.
All right. Thank you. All right, folks. I'm going to listen to a closing statement at this time, and I'm going to start with the pro se litigants and then go to the lawyers. So at this time, ma'am, is there anything you'd like to say in closing as far as this case is concerned, what I should do, ma'am? Thank you. I already know what you want, ma'am, but is there anything, any type of closing statement you'd like to make to that end?
Oh, I'm sorry. You talking to me? Oh, okay. The closing statement I would just like to ask is that the first when I first asked him to live with his dad was, like I said, was for postpartum, and the second was just until I was able to get a job here in Austin and get back on my feet. If I had been aware that because I had asked that I wouldn't be getting my son back at all, then I don't think I would have done that, and I don't honestly think I should be punished for asking for help from the other parent. I completely understand if you don't want to uproot the child. From what I was told by Miss Lambert, it would be basically impossible.
Okay, ma'am. Don't again. This is a closing statement, not a. I know you're not a lawyer. You know, don't say something that someone else has said. Just make your argument. Thank you, ma'am.
Okay. If it came down to it, I would suggest maybe every other week if I were to move closer to a school. If not, like I said, I would like to do maybe I get him a year, he gets him a year. But from what I was I'm not gonna say from what I was told, from my understanding, that is not possible. So I would just like to have my son more. I'm not. It's just been really trying a year for me, and I would just like to have my son more and more cooperation for co-parenting.
All right. Thank you very much, ma'am. Sir, Mr. Knox, you wish to make any type of closing argument, sir?
I just, want what's right for him. That's all. I really don't. I mean, I really don't have really nothing to say. Like I said, I just want what's right for him. I just want to make sure he's okay. Just want to make sure he's getting the support. So whatever decision is made today, I'm okay with it because I know y'all gonna make the right decision.
All right then, Ms. Lambert.
Thank you, Your Honor. I wanted to start by being very clear that I in no way, by my recommendation, mean to imply that I think that Ms. Brown is unfit or that the child would be harmed in any way in her household. I find her to be a very loving, mother who takes care of her child. And so my recommendation is not a punishment. With that being said, I am always going to be resistant to disrupting a child and uprooting them out of a place where they've been stable. And so my recommendation will be that the child remain with his father and his father be primary. However, I do highly encourage the parties to work together to co-parent because the child is so young. And I believe this could be a situation where mom would be endowed even more time if the parties could get along and work well together. So at the very least, Your Honor, if you make the father primary, I would ask that mom be given extended visitation for the first, third, and fifth, and then just encourage the parents to do what's necessary in order to make this as seamless a process as possible for their son.
All right, thank you. Ms. Bungat.
Thank
you. You went back muted, ma'am. Sorry. There you go.
Thank you,
yeah,
Judge.
don't get me started with computers today, okay? Thank you.
The state is requesting, Your Honor, appropriate rulings with regard to the state's request for retroactive support. While both parties were served in May of 2022, this child was only born in 2019. Was born in 2019, so we wouldn't need the full 4 years if the court finds it appropriate at all to set any amount. With regard to the child's health coverage, it sounds like we have a possibility of private coverage through mother or through the father's SSDI. The uncertainty is where the state hesitates to finalize at this point. However, based on the mother's testimony regarding her new job, the state has calculated that current support from her would change to $419 per month for child support and $46 per month health or cash medical, if the court ordered government medical through the father. That would begin on we're on October 31 today, Your Honor, so the state defers as to November or December beginning.
Right.
The state is not seeking a judgment for the past due child support, which was set from the mother at a minimum wage presumption. The father, as the state alluded to earlier, only owes 32 cents. The state's not seeking a judgment at this time. It's the state's belief that if money is due and owed, it'll come out eventually. And then with regard to other pleadings by the state, we covered it all, I believe, in the further temporary orders, Your Honor. And so, no, that was it. Thank you, Your Honor.
All right, folks, let's see. All right, what I'm looking at doing is go ahead and, both parents are obviously capable and willing to do what they need to do as parents. But again, ma'am, no one's saying anything against your parenting ability. It's just changing things around is always suspect and disruptive to a child. So I'm looking at going ahead and naming y'all both joint managed conservators, but I'm going to go ahead and give the father the right to decide domicile. I'm going to restrict that domicile to Travis or contiguous county, so you cannot move from either Travis or a county that touches Travis going forward. I'm going to go ahead and give you the extended visitation package, which just means, ma'am, instead of the first, third, and fifth Fridays of the month to the following Sunday, I'm going to go ahead and give you the first, third, and fifth weekends of the month, starting on that first, that's when it gets kind of suspect, that first Friday, but I'm going to go ahead and give you the extended package where you can pick the child up from school on Thursdays, or you can pick the child up from dad on Thursdays and return the child to school on Monday, or return the child to school to dad on Sunday. You need to pick one up front, ma'am. That way it limits the confusion. but y'all work through app close to make sure that going forward that's the way it's going to work. So if you want to pick the child up from the school, that's just fine. If you don't, then you can pick it up from dad, but you get Thursdays through the following Sunday or Monday, if you however you want to do it now. I'm gonna go ahead and then on those weekends that you don't have the child for the whole weekend, you do get automatically you get that Thursday also from 6 p.m. on Thursday to 8, so you get a little time with the child. I'm sorry, you get to pick the child up on Thursday from dad and return the child to school the following Friday. Okay, on those weekends, they're not your weekends. And obviously the standard visitation package going forward. I'm gonna go ahead and order that the mother be responsible for child support based on the time frame she's going to be have with the child. Instead of the $419, I am going to go ahead and order $345. I'll go ahead and order $325 a month on child support, and that's going to start the first day of November. Obviously, she has to the end of November to pay it. That's why I'm going to go ahead and do it that way. And I'll leave the ad litem on this one to work it out and see and double check that. It just didn't seem that if dad has Medicaid, the child should be eligible for the Medicaid. I'll say also. So since I'm giving dad the right to decide domicile with that package, he should be able to either get the child's on Medicaid like mom had, or through his Medicaid. So hopefully, within him having formal custody going forward, that'll work. And if that's I'm going to hold an abatement. A decision on whether or not to order cash medical. I also want the ad litem to check into seeing what mom's medical insurance, if dad doesn't work out with Medicare or Medicaid, what mom's health insurance is, and I'm going to hold an abatement of finding who's going to be responsible for health insurance until we work through those two different scenarios and we can figure it out. I'm going to go ahead and I'm not going to order any retroactive child support. The child was between the two parents off and on. It's just not retro. I don't think it's appropriate on this. I'm going to waive court costs due to both parties having had the child for periods of time during this matter also. And I'll go ahead and reset this matter for one of our November dates to get an update from the ad litem on that health insurance package. Neither party has to appear. The ad litem can let them know what we're doing, what the court decided to go ahead and do. But once you figure out if dad's able to get the child on Medicaid and or Medicare, that's the route I want to go. And then I'll just order mom to pay the $43 a month cash medical. If we're going to go with mom, then we need to come back in and figure out what that's going to do. And since I've already given her a reduced judgment, we will for child support. I will see whether or not what the overall expense is, and whether or not she'll be entitled to anything else for against that, as far as her having to do the health insurance on the child. But based off the top of my head, I don't think it's going to get beyond what I've already given her for the as far as the reduced amount of child support is concerned. So that was a lot of legal mumbo jumbo real quick. Miss Lambert, do you have a date you're coming back? I know there's a couple of dockets, a couple of things that the week after Thanksgiving that we're doing, and obviously the week before Thanksgiving. Are you there on either of those dockets, ma'am, or any of those dockets?
I don't have anything currently set, so any date that's available will work for me.
All right, so I'm probably going to look at that last docket. I think that's what I love about Zoom. It says they'll let me put everything into a Microsoft Calendar or a Google Calendar, but it doesn't. So let me bring back up Zoom's calendar and let's see what I've got. I think it's the last Tuesday of the month. Let's see. Yeah, that's the general docket on the 28th. You make that?
Yes, sir.
So I'll give you the entire month to see if you can find out and how we're going to do it. Of course, the parties, ma'am and sir, you're allowed to show up and let docket if you want to. But the only thing I plan on making a ruling on that docket is where the health insurance is going to be and whether or not it's going to be cash medical going forward, and whether or not I need to make any type of legal adjustment for mom having to carry the child on her health insurance through her job. So I'm going to start with you, Ms. Brown. Questions?
My only question is, so with this ruling, he's basically with his dad until he's 18.
Ma'am, that's not what I said. I know you're not a lawyer, but that's not what I said. Dad has custody. That can change tomorrow. That can change on his 17th birthday. But for right now, dad is the conservative with the right to decide domicile, ma'am. Next question, ma'am.
No more questions.
All right, Mr. Knox, question, sir.
I just want to know, so when so I can go try to file again for his insurance today, or should I wait till November 1st?
You have the right with a court order to put your child on. Right now, I'm going to go I'll have the state drop an order making y'all both responsible for health insurance if you want to try to do that. But for right now, sir, you need to figure out. And again, your health insurance is through Medicare or Medicaid, correct?
Yes.
All right. Well, tell them you got legal custody now of the child, and they should allow you to do that. And like I say, I'll have the ad litem work with you on that also. But at this time, do you have any other questions, sir?
No, that's pretty much it.
All right. Anything else, Ms. Mungat?
So until the 28th, Your Honor, you want it as a reset, or go ahead and make a second further temp with just parents responsible for health until we come back and flesh that out?
Yeah, go ahead and make it a second attempt. That way, they can they'll have a court order to show, hey, I'm responsible for health insurance by a court order, which means I don't have to wait for an enrollment under Texas law. So, and let's find out what each one of them can get, and then have them running through the ad litem to figure it out. Again, I want to go with Medicaid or Medicare if possible, and mom secondary. So I would want dad first and mom second. But if the dad can't get it, then obviously we're looking at mom.
Yes, Your Honor.
All right. Anything else, Ms. Bongat?
No, Judge.
Ms. Lambert?
No, Your Honor, thank you.
All right. Thank y'all all very much. Again, custody situations are always tough, folks. They're always always clear losers and winners on that circumstance. But again, these are circumstances we deal with, and I'm going to go ahead and set them up this way. And ma'am, you need to make up your mind how you want to do the pickup. Again, you can pick up from dad's residence, or you can pick up from school on Thursdays. But I'll tweak that at the final order. So after you set that up or make up your mind how you want to do it, let Ms. Lambert know, and I'll make that the final order. But again, your pickup is at either at school. If you pick up at school, the drop-off is the following Monday at school. So obviously you're 24 miles away, so that is a little bit of a trip. So if you want to do that, that's fine. Or you can pick up from dad on Thursday evenings and return to dad on Sunday evenings if that's what you want to do. So talk over, give it a day or so and make up your mind how you want to do that one. All right. Or if you're willing to tell me right now, I'll go ahead and make that part of the order, ma'am. So do you want to think about it, or do you want to go ahead and do it now?
I'll think about it.
All right. Thank you. Yeah, because you got to figure out the logistics of getting to the school at 3 o'clock or whatever time it gets out. Yeah. And Bell County is bad at traffic, but Travis is Houston from the when I was in law school.
Yeah.
So yeah, it's bad. So yeah, what used to take 30 minutes will take you an hour and a half. So good luck with that. Anyway, let Ms. Lambert know what you want to do on that, and she'll let dad know, and everybody still use App Close to do everything going forward. Hey, I'm running late, or I'm stuck on I-35, or I'm stuck on the tollway, whatever it is. Let the other person know what you're going through, and everybody work through that. Okay.
Okay.
All right. Thank you everybody very much, and I'll see either everybody back on the 28th, or just Mrs. Lambert with an update on that health insurance and that pick up and drop off by mom on her first, third, and fifth weekends. And ma'am, also on the individual Thursdays, again, you could do the pickup at dad's, but the drop off has to be at school the next day. Okay.
Okay.
On the Thursdays, and that you don't have the weekend visits. Okay. Thank you. All right. Again, thank you, folks, and we're off the record.